It was mentioned earlier that maybe we're preaching to the choir, which I have always said is good for the preacher and good for the choir too. But I don't know, I find this a tough audience. It's a tough audience because they see a lot of faces who have been through a lot of struggle out there, a lot of people who have suffered. I was introduced to Nadine and her brother Muhammad, who were held right here in Seattle for 90 days. She's 21 years old. There's my brother and his friend from the old hometown, so I really have to watch my P's and Q's. There's Len Schrader, who was out with Thurgood Marshall on Brown versus Board of Education, longtime member of the Guild. These are people that are monuments in and of themselves and that should be declared national treasures, just as the Japanese do, if not by others, certainly by us. John Britton in New Haven in the 60s and 70s doing what was the right thing. All these years of struggle, and some of those Seattle U students that were asking me the tough questions, not impolite tough, not haranguing tough, but just tough questions about the case. And what is my answer to this? And what is my answer? Some of them have returned tonight. So I think this is a choir, but it's a particularly resonant choir, a choir where I can preach and we can all come together. One of the reporters, when I was arrested, said, well, what's the issue here? Is it that Ashcroft can just arrest anyone, anytime, anywhere? And I said, well, that may be true. But the issue here is, when he does it, will there be any lawyers to call? Because my case is really about the activist lawyer and whether the activist lawyer has become a detriment or an impediment or a, how would you call it, a burr in the machine of criminal injustice perhaps, but the system as it now progresses. Because it's not only the criminal defense lawyer that this regime considers to be an impediment, it's also those tort lawyers, those guys that get money for the poor woman who in the Bronx whose child was delivered virtually stillborn because some medical practitioner did not act properly. Mr. Bush would like to live this child's claim to $250,000 because those lawyers are just getting too much money. Can you imagine? It literally takes your breath away to think about his value judgment when the money that this man has stolen and allowed others to steal, the contracts he is handing out, and he has not a qualm in the world of limiting the poorest among us, the least able to survive without some kind of justice in this world. My case, definitely about defending the right to defend. It's not my personality, it's not even my client's personality, although I think some understanding is necessary to understand the whole case, but it really is about the activist lawyers and the lawyers who refuse to take direction from the government as to how a case shall be conducted, who listen instead to their clients, who represent not just a human being with a set and a history, but also a politic that that client needs to preserve as part of his defense, as part of her persona. And I think we see this. I know Larry mentioned Debs. Well, how many of us really realized that Debs was defended, of course, by Darrow, and while he was being defended in jail, he ran for president of the United States, got 10% of the vote, and was able, of course, to do this through the lawyers who, if they had had SAMs back in 1920s, the special administrative measures promulgated by the Bureau of Prison, which prevented lawyers from carrying out any message, surely would only have gotten 5% of the vote. It is a long tradition. The lawyer for the accused political person, for the person who indeed uses as part of his defense, not just at the time of indictment, not just at the time of sentencing, not just through appeal and post-appeal, but indeed during long years of imprisonment. And we know about the political prisoners imprisoned in this country, people who have been there since the early 70s. I talk about Mutulu Shakur and Marilyn Buck, Kathy Boudin. Whether or not you are enamored of their politics or their methods back there, they have all served more time than any criminal, end quote, would ever have served on the same charges. I can remember Sekou Odinga, whose 18-year-old son now works as an intern in my office. I can remember giving his opening in a trial involving the Black Liberation Army, Weather Underground, and the May 19th organization, where Sekou said to that jury, and actually had some of them in tears, when he said, "If I am a criminal, why don't they treat me like a criminal? Instead, they torture me because they know what I stand for." And he recounted the details of the police who arrested him, thrusting his head repeatedly into a flushing toilet, choking, almost in his feeling, drowning him. And he said to that jury, "Ask yourself, why am I on trial? I am on trial for my political convictions, not for anything which I have done." He too, he is at Marion, one of the most repressive places in this country, and I could spell out all the others because indeed there are plenty if anyone is interested in corresponding with these people, and believe me, it's a lively correspondence. And I say that because my original point, they have not lost their politics over all these years. They maintain their politics at the denouement day of 9/11. Indeed, the Bureau of Prisons locked up everyone who was political. They didn't care what stripe political. The Aryan Nation was locked up with the Marxists and held until that particular prison decided they could let them be back into population. I say this because one of my clients, who had been in jail since 1984, was indeed held up until February of this year, held without the ability to get a book to read of his own choice, had to read from the prison book cart only, which sometimes came. Medical attention he was not given, visits he was not allowed to have, phone calls he was not allowed to make, and they just lied to us and lied to us and lied to us that he was about to be transferred. He had been in this prison, Lompoc, California, for over 10 years, no problems, no disciplinary things, nothing. They just decided he was dangerous, or they decided he and I were dangerous together. I don't know what that answer is, and we may never know, but we do know that Richard Williams, who I am close enough to that I send him the New York Times crossword puzzle every week, and who we engage in lively political debate by phone or other ways, was in fact given this kind of treatment. But I want to talk to you a little bit about my case, and I apologize to all the people who were there this afternoon and have to hear this twice, but I think everybody needs to know exactly what the charges are, so when challenged by those who put up the Federalist, and I say that with a capital F, not a small one, posters around the school claiming that I shouldn't even be allowed to speak, so we can counter their particular invective. And I do also want to say that in defending the right to defend, there is no organization like the Guild, and any lawyers who are here who have just let the Guild lapse in the last few years because, you know, we get so involved in our own particular narrow field. I want to be a member of the NACDL, and it costs $250, and let me join that and go to their CLEs and get something for my money. And I better remember that in these times, the Guild is where we better be united, because the Guild says human rights before property rights. And if that isn't anathema to this particular administration, I don't know what is. They've always been there. They were there for me from day one. They were there for me. They have been so instrumental in letting me be in so many places all over this country, in sponsoring me, in giving me a forum, in helping set up the Lynne Stewart Defense Committee. And as Michael Tiger, my wonderful lawyer, says, we have seen the future, and it is expensive. So. So remember those magic words if you happen to have a check on you that you'd just like to get rid of. My case started about a year ago, and it started very abruptly because I was arrested at my own home in Brooklyn, arrested custodially, cuffed, taken to the waiting unmarked FBI car, and taken away. I always like to say that as I was coming out the door, I heard my husband saying, Ralph, who's here in the front row, without whom, I mean, there's Larry and Karen, but long before that, there was Lynn and Ralph. And 20 years for 20 years I was Ralph's old lady while he fought and struggled in the New York City schools to bring about community control of schools. And then for the last 20 years, he's been Lynn's husband, or Lynn's old man. Obviously, we all know the value of a great partner, that makes it so much better and so much easier. But Ralph was out on the front stoop. A stoop is like the little front part of New York City houses where people hang out and play stickball, not stickball, but hit the ball on the step and catch it, and stoop ball is what it's called. And so I'm coming down the stairs and I hear him, and it's a very modest brick row house, not the townhouse the New York Times article called it. If any of you read that, I'll comment on it. It's probably not worth wasting everyone's time with, but it has a history that profiled me. Anyway, Ralph was waiting on the front stoop, and I hear his voice, and I hear him saying, "I don't see a warrant, and I don't see any badges either." I look past him, I see the guys, I know this is what they like to call law enforcement, what we like to call cops, and we called other things in the 60s, but I won't lower myself to malign a great animal. And I step out on the porch and I say, Ralph, it'll be okay. I said, just don't make it worse than it is. Don't carry on with these guys. We'll have you out by lunchtime. Because Ralph has been known to be arrested going to a PTA meeting in Brooklyn. At which point the burly FBI guy steps up, points at me and says, "We're not here for him, we're here for you." Well, I tell you, from the heart and from the brain and from whatever else matters, I was absolutely flabbergasted. I am flabbergasted and outraged today. That day, I was so angry that when I got in front of the judge, it didn't seem enough to me to just say not guilty, murmured in the usual way by a hopingly repentant defendant. And so I said emphatically not guilty. The courtroom was filled with lawyers because I hope one of the miscalculations General Ashcroft made was that you can't practice law in New York City for 30 years and not be the person you are and not have your colleagues and your friends and your associates know who you are, from seeing you in court, from co-counseling with you, from talking about cases, from being stuck in the attorney visiting room endlessly, from all the things that all of us do all the time. People know who you are, and when we got to court that day, that courtroom was filled with lawyers, some with the Armanis, some with the Rolexes, others with the corduroy pants and the pullover sweaters, but at least 5 people had come up to Ralph and said, she's not staying in jail, not even for one night. I have my deed, I have my condo papers, I have whatever it takes to get her out. Which was really overwhelming because, you know, when you practice my kind of law, it's not exactly not-for-profit, but sometimes it seems that way. And when you're caught up the way we were that day, and we realized, you know, he's trying to think we have a country place that we go to. How do we mortgage the country place? How do we do all this? And to have those folks step forward was really such a vote of confidence. I did, of course, get out. I was allowed to be bailed by my 3 children. My son, with whom I practice law, my daughter, who thinks she's not political, but we laugh at her because she's such a gadfly. She's in landlord-tenant court as a pro se representative. In other words, all the tenants who come in without lawyers. And my daughter, the doctor. So they agreed they would take their signature in lieu of $500,000. And so I am held in $500,000 bond, but it only is payable if I leave, and I'm not leaving. The charges against me are the materially aiding a terrorist organization. These are charges that have been used against so many people in such a wide variety of situations. An Iraqi doctor who sent blankets, Sammy, down in the University of Tampa, who wrote checks to Hamas over 20 years ago and who is still incarcerated. The higher-ups, the Lackawanna Six, who went to Afghanistan 4 years ago and trained and came back and never acted, never did anything. This is a very broad law. It is very hard to figure out what might be and what might not be materially aiding. And the definitions are not helpful. And as one of our motions, and if you're interested in that, our website, which is recited on all our literature, www.lynnestewart.org. We have a full set of our 120-page motions which address this statute, the use of this statute, and more importantly, address the First Amendment and me. That the crime of which I am accused is a pure speech crime. I have First Amendment rights. I believe even as an incarcerated person, my client had First Amendment rights. The government had promulgated regulations counter those First Amendment rights. And it was our belief at the time that I made a press release on behalf of my client, Sheikh Omar Abdel Rahman, that his First Amendment rights trumped their prison regulation. And we have raised in our motion papers that question of pure speech, an act of pure speech, the press release, my releasing of it without comment, and whether or not this meets the standard under the First Amendment of being a pure speech act without any action accompanying it. Dr. Spock had the great case. It has to be accompanied by some immediate action, or else it is not a crime. The government computers do not do much First Amendment stuff. It took them over 2 months to answer this motion. It is still pending before the judge. They asked for additional time to reply to our reply. This is not yet even reaching that part of the case which most people know the case by, and that was the violation of the attorney-client conversations, the sacred talks that attorneys have with clients. When it's one-on-one, this client is free to tell you his or her innermost secrets because they know that you are constrained under law and under ethics not to repeat anything that is said to you unless the client releases you to say this. What happened was, after the press release was made, and I use this we, and I know people say, who's we anyway? Well, we were a team. I was recruited to the Sheikh's case by Ramsey Clark because he had been approached by a group of persons who were very concerned that Sheikh Omar, who was an extremely important personage in the Middle East, someone respected, a graduate of Al-Azhar University, a PhD, even though he was blind, in Islamic studies, someone that was a truth teller and trusted, seemed to be heading to court pro se, meaning representing himself. He did not speak English. As I say, he was blind. He was not familiar with the American system of justice or injustice. And this group came to Ramsey and said, we really must find a lawyer for the Sheikh. It will make the people we believe can sympathize with us. It'll look as if America cannot provide a lawyer to someone we consider very important. And that can't be true. So Ramsey called me, he called a group of other people, we all interviewed the Sheikh, and I came back and agreed to represent him after only what I can call an attorney general's arm twisting, because it was my view I couldn't possibly prepare for this trial, I couldn't possibly be ready, I couldn't possibly, etc. And he, using methods I'm sure he's used on others in other situations, some of which we may not be so happy about. I know that my own husband was saying, remember this guy was trying to arrest us back in the 60s. But I think Ramsey has redeemed himself since then. Certainly his work with Iraq has certainly, and his representation of Pelletier and of so many activists, so many unpopular activists and people that I personally probably wouldn't represent because I would have too much animus from my own personal view. He is able to be the quintessential liberal and represent them. And when we made decisions about the Sheikh's case, we made them jointly, all of us. Abdeen Jabara, who was the third member of this team, was also a lawyer who visited the Sheikh, who took the Sheikh's phone calls, and who was part of this group. We found out only after the arrest that they indeed had bugged the attorney-client room in the prison, that they had not only bugged it, but they had set it up with videotape, that they also had listened to all of our phone conversations with the Sheikh for the last, was about 18 months at that point. And this was part of the basis of the prosecution. That part of it, I must say, although to me the horror of it is that they're listening in and we don't know what they're going to use or when they're going to pull it out of the hat or against who or where. But at this point, the real focus of our defense is on this press release and on the subsequent events. Because I did make a press release. The press release was asked for by the client. It was not done surreptitiously. I called Reuters, which is a very large press organization. I read the press release word for word as it was translated to me, and as a footnote, of course, the interpreter is also indicted in this case, which is really bizarre if you think about it. They're, without any real knowledge whatsoever, without any proof whatsoever, they basically, because he was speaking Arabic to them, they're making a number of giant leaps which are not borne out in the evidence at all. At any rate, I called Reuters, I gave them this press release, they called back, they fact-checked, were you really visiting, are you really his lawyer, is this, and it finally was printed only in the Egyptian newspapers. It was not picked up in this country at all. And it basically went something like this. It said, although I'm in the middle of Minnesota, in Rochester, I don't get any Arabic news except what's read to me over the telephone once a week. I really don't know what the situation is. You guys are much closer to it, but I think you ought to re-examine whether or not this truce, this that we have entered into with Mubarak, is being lived up to on their side. Without going into a whole human rights thing, I want you to know that, of course, the Mubarak regime is one of the most repressive in the Middle East. It is cited by the Human Rights Watch as well as by Amnesty for the atrociousness of the torture, the jails that are filled with political dissidents, and Mubarak, who has never had an election in 20 years except those in which he was the only candidate. It receives the second only to Israel in money received from the United States for aid. Mubarak now has a private island in the middle of the Mediterranean, where undoubtedly, like all good dictators, he will someday run away to. We hope. Sooner the better. This press release basically went to a ceasefire that had been entered into by a group the Sheikh had been associated with, the IG, Gama Islamiyah, and excuse me for my pronunciations, the Islamic group, and ended by saying, but as I say, you are the guys that are there, I'm not there, and I am not urging a breach of this truce, just an examination and no resorts to violence. This was reprinted. It caused a big furor because the Sheikh is a personage. He's a very significant player, as they would say in Washington, and someone that is widely respected. It is not as it would be portrayed by the press mostly, some call to arms on his part, some saying, go pick up the gun and let's get going again. He is, after all, he'd been out of the country for almost 14 years at that point. He was never part of operations. It was not a question was asked of me this afternoon, which was an excellent question about the coded nature. Could this have been a coded question, a message to his followers in Egypt, which gave them directions? And I think even in our most paranoid and fertile imaginations, and that is, of course, what we're dealing with the justice and state and all those departments, it is very hard to see how this could be a coded communication and what it would mean. And even if it did mean something, John Ashcroft answered that question 2 years later when asked at the press conference that he held at Ground Zero that same day they were clicking the cuffs on me. The press said, well, what happened after she made the press release? And he sort of tossed off, oh, nothing happened. That night, of course, he, understanding the great mega, what would you call it, mega influence of late night television, went on David Letterman. I think this is unprecedented even for J. Edgar Hoover or Palmer. Of course, they didn't have television. But he went on, David Letterman, sang the song he wrote, Screaming Eagles, and then proceeded to whip up this audience. Of course, he had the applause signs he could use back there, but cheering him for fighting terrorism, for going after that lawyer in Brooklyn, the terrorist lawyer, the grandma with 7 grand. But I wasn't arrested, and we all know that because I'm a grandma with 7 children. He didn't go in the phone book and say, who can I pick out of here? He knew who I was, he knew how I represent, he knew what my position was, and it was important to him to either break that position, arrest that position, send out that position to lawyers to don't be like her. Because I think what we see these days, and I know my colleagues at the Guild have written on it extensively, is that lawyers are increasingly minimized in the criminal justice system, whether it's state or federal, but particularly the federal system. And we see these inroads every day, every week. All you have to do is kind of catch the small print in the papers. The FOIA was suspended again during the first week of the Iraq War. The FOIA that gave us our first indications about Henry Kissinger and his war crimes, the FOIA that has been so instrumental in bringing to light papers and reports that have freed people all over this country because of the involvement of the FBI, particularly in political cases. Just last week, an amendment or a rider, the famous riders to the bill, a congressman added a rider to the Orange Alert Bill. The Orange Alert Bill had to do with children who are kidnapped and sexually abused, and the need to pay attention and have this go out on all states and use all our computer tech. Who could be against such a thing? Well, nobody. And when they tacked on another rider that said that federal judges may not depart downwardly on federal sentences unless approved by the prosecutor. I represented a Native American woman. She had 4 teenage children. She was, the gravamen of her crime was she picked up her husband when the van that he was transporting illegal Chinese aliens who had come across the St. Lawrence River to the Mohawk Reservation broke down. She had 4 children, a mother with Alzheimer's. She was not in great health herself. We made a motion for a downward departure based on extraordinary family circumstances, that all of these innocent people should not have to suffer, that her husband was going to jail, there would be no one, these children would be split up and put into foster care, and the judge agreed and sentenced her to house arrest. The prosecution opposed this downward departure. If she were to be caught tomorrow, she would do approximately 2.5 years, and what would happen to her children is anybody's guess, or her mother, or indeed their whole life. So it's a particularly vicious, why they said that, I'm tongue-tied here, 9% of the judges had ever availed themselves of doing this. This is not something so widespread. And to understand this, you have to know that the federal sentencing scheme is a grid. If you did this crime and you're this kind of person, a 3-time loser, a 2-time loser, a previous violent crime, previous drug conviction, you come to a spot on a grid. And that spot says 16 to 18 months or 24 to 36 months. And wherever you come out on the grid, that is the sentence you're supposed to get. That's supposed to be fairness in sentencing. Takes completely away from the judge any discretion he may have, except that we could ask for downward departures for specific reasons. So when I say this comes, it treads very lightly. It insinuates itself in, it shreds the Constitution, because of course that is cruel and unusual treatment in my view, and punishment, and it leaves us with a heartland of a Constitution that protects nobody that has no longer got a Bill of Rights. Because it doesn't happen by striking it out with magic marker and throwing it in the garbage. Take away little by little until you slip down that slippery slope and there's no more there. I think we were able pretty well by the outrage to defeat the TIPS program, where your cable TV provider was going to come in and tell what books you had, and Poindexter's, the thrice criminalized Poindexter and his wealth of information. That sort of is in existence, but not to really. The brave person who leaked Patriot 2 sort of set us all up to know this is something we want to fight, unless we want to find ourselves on an island, and it's not going to be Guantanamo, I don't think. They don't want us that close to Cuba, I don't think. We'll be on Devil's Island or the Dry Tortugas or something. And, of course, what is still ongoing is the library program, where they can serve a subpoena on a librarian. She must tell them what books were borrowed by a certain person. She may not tell the person, nor may he or she even advise their superiors that they gave out this information, much less go to a lawyer. That's completely forbidden. And it's recited on the face of these subpoenas. And the military is still going into the high school, where they're empowered to take the addresses of all high school students and send them a letter from Uncle Sam, which doesn't say, what did they used to say in the 60s? Greetings, right. No more greetings. Very pointed at, you should join us and have a free scholarship. And I saw those kids going off to Iraq, just enough to break your heart. But our fight, my fight, is the narrow fight. It's the fight to keep the right to counsel, the right to defend. It does involve the First, the Fourth, the Fifth, the Sixth Amendments. It's ironic that in the 50th year of Gideon, which was greeted as a great breakthrough, lawyers for everyone, even those who could not afford them, a case that came up through a pro se client who wrote his own briefs and got the Supreme Court to rule in his favor. And on the 50th anniversary, we are so far away from the right to counsel that we have unthinkable people sitting in Gooseneck, North Carolina, that have not seen a lawyer and who the government has no qualms about saying to us, we're very close to turning him, we're very close to getting his cooperation. If you let a lawyer in there, it's going to interrupt that process. Isn't this not torture? Is this not what we're talking about? You isolate, you put someone in conditions where they're cut off completely, they have no one to talk to, you pose as their friend, and another poses as their enemy. Isn't that what those of us who came up through the Korean War were told? That's what those Chinese communist interrogators did. And aren't we doing it? And aren't we countenancing it? There have been some articles that have been written by lawyers saying what my case has meant to them in their practice. Susan Jordan, a San Francisco practitioner, wrote in the Guild notes that when she goes in to see a client now, she first in her head has to think it through. Is she going to take notes? Is she going to take notes and rip them up and try to flush them down the toilet before she comes out? Is she going to take the notes but give them to the client to keep? Is she going to not talk to the client but make everything be written? All of those decisions she said she never had to make before. All of those decisions we all felt assured that even if the government was listening, and we were sure they were because that is the way they operate, they would never use it, they would never admit it, because it took the veil away from them and revealed who they truly were. I also would recommend to this group reading the New Yorker article on John Walker Lind and about a brave young lawyer named Jesselyn Raddick, nobody knows her name even, who advised the captors of Lind that they couldn't talk to him without a lawyer present. They had gotten a notice, the Red Cross had gotten a notice, the Attorney General had gotten a notice, and they asked her advice, should we talk to him? She was a new graduate, she was a double major at Brown and a law school graduate. She was one of their bright people. She wrote back, she said, you can't talk to him. Can't speak to him without his lawyer being present. She got back an email. The email said something like, don't send us any more emails like that. So of course, Jesselyn, thinking she had a job to do and that she was protecting national security, wrote back again and said, I'm telling you, you may mess up this whole investigation. It may be useful for national security, but you will never be able to use it in a prosecution. Don't do it. She got no answer this time. After Lynne was brought back, his lawyers demanded all of the correspondence surrounding their filing of the notice of appearance and what the response of the Attorney General or the Department of Justice was. When she read this in the paper, that the judge had ordered that, she went to her superior and she said, did you send them my emails? The superior said, this is what we sent them. It was a paper folder with about 3 documents. She knew that there was an inch-thick folder when she had worked on the case. She went back to her computer, went into her trash bin, brought all that stuff back up, and then leaked it to the press. For this, yeah, good for her. I agree. For this, she was informed that she better look for another job. She'd never continue working with them. She got another job, and at that point, that job was informed that she was under investigation by the Department of Justice, and that if they wanted to take a chance with her, they could, but, so now she's unemployed. We don't hear anything about her. She has an attorney who's a whistleblower lawyer that specializes in these cases, but there is no case. There's only them and their desire to make sure this young woman doesn't have a career. When I read this, and then of course what was subsequent to that, which is of course just what we all know, that because of this, because of her leak, they then could no longer prosecute Lynne. So they gave him 20 years, and he's sitting in a medium security jail. This is the guy that Ashcroft went off on. He'll be in jail for the rest of his life. They had the father of the dead CIA guy in crying in court. He has to go to jail for the rest. But this is the best deal they could work out without showing their own dirty tactics. So it always does come back to haunt them. And it's my view that listening to attorney conversations does not forward even their program. It does not forward anyone's program. All it does is give them a false sense of security that they know what's going on, and they don't. So, as the government puts the justice system under more and more under their control, what are we going to do? Well, we're going to fight this case. We're not going to give in. I just feel that putting a public face on it and getting out here in front of folks like yourself is the right thing to do. And you know, I'm reminded, my husband likes to tell the story of when he was a small boy growing up in western Pennsylvania. His father was a union organizer in the coal mines and steel mills there. And little Ralph came home one evening and told his father a long tale of racial injustice. How he had been called certain N-words by the local guys, and his father had only one quick put down his paper, which was probably the Pittsburgh Courier, put it down, looked at Ralph and said, and what did you do? And I think that's what we each have to say to ourselves. We each have to say, and what did you do? This was coming. This was on the horizon. This was a smoke signal to you, and what did you do? Did you just sit back and let it steamroll us? Did we stand up? Did we join with others? Did we try to talk it up? Did we mention it to people, even those whom we thought it was an unmentionable because we know their politics? Did we try to bring people together through enlightenment instead of just allowing the divisiveness that's taking place? What did we do? Well, I know what I'm going to do. I'm going to keep on fighting this because I have a sense that we have to win this one. We have a tactic whereby we pack the courtroom. We call upon all our supporters whenever we go to court, and I would say to you, have a marvelous lawyer, Michael Tiger, a longtime fighter in the constitutional wars and in the wars of political people. He is worth the price of admission alone. And when you get about 70 or 80 or 100 or 200 people in a courtroom, it changes the terms. Most of these federal courtrooms, they're big empty sepulchers. They echo the tears of the mother in the first row are the only sound, and it's you and your client, and you are definitely alien to the place. But it's an interesting thing how that changes. When you put in 100 or more cranky New Yorkers, mostly activists, who have been asked to wait in the hall for an hour and given a number by a marshal who was once a New York City cop and is now moonlighting, and sort of herded around. By the time they get in the courtroom, they are going to stand for no nonsense. And the U.S. attorneys, who are young people who have gone through Harvard or Yale and then clerked for a prestigious Southern District judge and then got a job in the U.S. attorneys, they're very, very, they're not used to disapprobation. They have basically been told all their lives, good job and proud of you, boy, that kind of thing. And when they're in there and there are these people who are so obviously disapproving and who feel that, what are we doing here on a nice afternoon? We don't want to be here, but we're here because you guys are bringing this ridiculous prosecution, and who are so proactive in the courtroom that Michael Tiger has to plan his answers. When the judge will say, well, surely, Mr. Tiger, you're not suggesting that the government lied. Michael will hold that question just the right amount of time and answer, why, yes, Your Honor, I am, before that audience answers the question for him. But when I say that we must win, I have two friends who adopted a small girl from Ethiopia. She was a polio victim who, because of economic circumstances, had been dumped at an orphanage. She is in a wheelchair. She will never walk. She will never be able to straighten up. But she is a blithe spirit. And Turhan came to Burlington when I spoke there with her mothers, and she, at the end of the speech, she insisted on coming up in her wheelchair and putting the $5 bill in the basket herself. And when I saw that, I said, for Turhan and all the children of the world we love, we have to win this case. We can't let them have a world that is headed in the direction this world is headed in. My case is a small part of it, but an important one. And I ask for your support, and I say again, we must win. Thank you.